to today's webinar on tort liability and risk management. This is Victoria Beal with the Ohio LTAP Center, and I am so very pleased to be able to host my colleague, Ron Eck from the West Virginia LTAP, who will be presenting on the topic today. I have to tell you that I have heard a lot of presentations about tort liability, and I feel that Ron's is one of the very best that helps to translate this sometimes difficult legal concept into very plain English that makes it easy for you to understand and hopefully apply in your workplace. So with that, I have a couple of housekeeping items. Anytime during the webinar this morning, if you have a question for us, please put it in the question box. I will be stopping Ron throughout the presentation, and he'll also take some breaks as needed to answer questions. And there is a handout in the handout section of the GoToWebinar box, but if you cannot download it, don't despair. I will be sending out an email later today with a link to that handout and hopefully a recording of the webinar. The technology doesn't always cooperate with us, so I am glad you are here live and in person to not only get your certificate of attendance for hopefully some CPD credits, but just be able to hear the presentation in real time and ask the questions that you have. So with that, I'm going to turn things over to Ron. Are you ready?
Ready, Victoria. Thank you very much for that introduction. Welcome, everyone. Pleased to see so many people turning out this morning for tort liability and risk management. As Victoria said, I'm Ron Eck with the West Virginia LTAP, which is based at West Virginia University in Morgantown, which is where I'm joining you from this morning. There's my email address. Feel free to make a note of that and reach out after class if there's questions or concerns. I'm always glad to try to help. So let's get started. Here's our agenda for the 3 days. Remember, this is day one of the 3-day session. Today we'll talk about tort liability, what it is, what it isn't. We'll also talk about the tort claims process, as I call it, meaning from the time a lawsuit is filed until it's resolved, whether it settles or whether it goes to a jury trial. We'll talk about that. We'll probably also talk today about what I call some common problem areas such as signing and marking, temporary traffic control, drainage, that frequently can lead to tort claims against road agencies. Tomorrow, our day 2, we will talk about some more common problem areas, and then we will focus mainly on risk management strategies from 2 perspectives, one from the organizational perspective, your organization, your agency, but then also kind of personal risk management, and we'll talk a little bit about that. And then day 3, Thursday, we will dedicate to what I call some case studies. What lessons can we learn from actual lawsuits that have been filed against state and local road agencies? So we'll do that on Thursday. My objectives are pretty straightforward. I hope you'll understand by the time we're done the importance and implications of tort liability risk for road agencies. We'll review some legal aspects. I will talk, especially today, about some legal terms, and I'll apologize up front for that, but I think to understand this field, we do have to understand some of the legal terminology. And then also, I hope you'll identify ways to reduce risk, as I indicated, both for your organization and for you personally. Since we are talking about a legal topic, I guess we need to have some disclaimers or some caveats at the start. So let's go through those briefly. I am an engineer. I'm a civil engineer, worked in the traffic pedestrian area pretty much all of my career. I've also done some forensic engineering on the side, and so have been involved in that process. But I am an engineer. I'm not an attorney. I'll try to share with you some of what I've learned over my career, but I'm not offering legal advice by any means. I'm just sharing my experiences. Also, I'm going to be speaking in generalities. Of course, laws vary from state to state. Individual cases or suits may look very similar, but in fact, they're different. And so just because you read that on the other side of the country, there was a $10 million verdict against a road agency for let's say a signage issue, that doesn't necessarily mean that it could happen in your jurisdiction. It might or might not happen to have a verdict of such a magnitude. So I'm going to talk mainly in generalities. A couple things I did want to mention, though, relating to kind of my personal thoughts, is one, I think in the United States, the media often tends to focus on what I might call unusual verdicts. I guess that probably sells ad time or that sort of thing. And so that's what they'll focus on. And it may give us maybe a distorted view of the situation. For example, I think a few years ago, maybe some of you know more about it than I do, but I think it was in the Houston, Texas area. Apparently a woman was going through the McDonald's drive-through lane, and among other things, I guess she ordered a cup of coffee. And as that cup of coffee was handed to her, something happened and the coffee spilled into her lap, and I think she suffered serious burns on her legs, and so filed a lawsuit against McDonald's. And I believe it went to trial, and I believe there was actually a large jury verdict against McDonald's or in favor of her as the plaintiff. And I've heard some people say, wow, didn't she realize that when she ordered a fresh cup of coffee, it was going to be hot and there was a potential for, suffering burns. And I don't know all the details of what happened in the courtroom, but that's what I would call kind of an unusual verdict or unusual case. To me, the reality is that in roadway related cases, way more often than not, if the road agency representatives and attorneys do a good job of what I call educating the jury about how road agencies operate, the constraints that road agencies face, those kinds of things, way more often than not, the jury will render a verdict in favor of the defendant road agency. So that's the good news, but also probably that's kind of maybe mundane or not out of the ordinary, and that's not going to sell ad time in the media. And so we don't usually hear about those kinds of cases. And like I say, to me, that's the good news, is that oftentimes those cases end up where a jury will render a verdict in favor of the road agency. So keep that in mind. The other thing to keep in mind is that sympathy can and does play a huge role in some of these cases, especially severe injury cases or death cases, or especially maybe where young people are seriously injured or fatally injured. Sympathy can play a role, and that may cause the public agency attorneys to try to resolve or settle the case rather than going to trial. Because oftentimes in a trial, maybe some of you have been jurors in cases in the courtroom, and the judge will actually instruct the jurors, that they shouldn't let sympathy enter into their decision. It should be based on the evidence and the testimony. But just human nature being what it is, if the trial goes on for a week or two and there's a young person who maybe was a healthy, active young person, and now they're confined to a wheelchair, if the jury members see that individual needing help to be their wheelchair be pushed in and out of the courtroom every day, sympathy does, just by human nature, play a role and can affect the jury verdict. So keep that in mind as well. And there may be a few examples as we go through here where I will talk about the role of sympathy in the resolution of the case. So those are the caveats. I'd like to start with an icebreaker exercise, and we don't have the actual scenario for you to read, but if you'll bear with me, let me kind of read the scenario here, and then we'll ask you a question about it. The scenario is we have Joe, who's a 17-year-old high school student, and he's taking Sally, his date, to the school prom. When it's time for Joe to leave home to pick up Sally, the family car won't start. And so Joe's dad, who's employed by the city, tells Joe to go ahead and take the city vehicle, but to, quote, be careful. So they go to the prom, and during an intermission at the prom, Joe's buddies persuade him to join them in the school parking lot for some rum and cola. Joe has several drinks. Sally doesn't drink any alcohol, but she's aware that Joe has been drinking alcohol. So the prom continues and concludes. While taking Sally home, Joe is startled by a large tree limb in the roadway. He can't stop the vehicle in time, and the car hits the tree limb. Sally is seriously injured. The limb fell from a tree on private property. A number of limbs on that tree extend over the roadway right-of-way. The roadway is state-owned and maintained. The tree is a type that's quite brittle with a propensity to drop limbs. A witness stated with certainty that he drove through the crash site 5 minutes earlier and there was no limb in the roadway. So this limb must have literally come down just minutes before Joe and Sally arrived on the scene. During the evening, the weather was intermittent rain with moderate winds. State DOT employees testified in deposition that they had never known of any limbs falling from that particular tree. However, during the depositions, these same state DOT employees acknowledged that limbs have fallen a number of times from other trees of the same type. So based on this scenario, which I've just described, who do you think might be facing a lawsuit, or who? Sally would be the plaintiff. She was the injured party. Who might Sally or her attorneys sue? And if you just want to type into the chat your response, Victoria will just call out a sample of those so we can see what people are thinking. But who do you think would have a lawsuit filed against them? Joe's dad, the city, the school district, the property owner, the state DOT, the source of the alcohol, or another party? And if you answer other, that's fine, but if you wouldn't mind identifying who that other party would be.
Well, Ron, we're getting quite a few responses here. The first one in the list said Joe and the state, and then road agency, Joe's dad. The city seems to be popular.
Okay.
Let's see, A and B, it's got the city again, and actually all, somebody wrote.
Okay, interesting response.
Yep, somebody put down G, but did not give us who else it would be.
Okay.
They said that was all the above, sorry.
Okay.
The property owner, so, oh, here we go. This is the answer I was thinking, the deepest pockets.
There you go. Yeah, that was the term I was hoping would come up. Thank you to whoever mentioned that. Yeah, if you think about it, what the plaintiff's attorney in this case, and really in any roadway related case or any lawsuit, what they are looking for is what's called the deepest pocket, or who has the most financial resources to bring to bear to compensate the victim, the plaintiff, for their injuries or for their damages. And in this case, notice we have a number of potential defendants. And actually, I would agree with those of you that responded all or each of these parties, because I think each of them would, at least initially, probably have a lawsuit filed against them. Some of them may get out of the case, or otherwise not be in sort of the final edition of the case that might go to trial. But I think initially all of these parties would be sued. Notice I didn't put Joe in there. You might say Joe bears the ultimate responsibility since he was operating the vehicle and he was impaired. But the reason I didn't put him in there is that Joe is a minor at 17 years old. And he really, if you think about it, I don't mean any disrespect to Joe, but he really doesn't have any financial resources probably to speak of to bring to bear to compensate the plaintiff. So the plaintiff's going to be looking to, for example, the city or the state or the property owner or the school district. No, the school district is interesting. Notice this wouldn't be kind of a typical roadway case. This might be a sort of a failure to supervise. The school district, the school grounds is where the prom was taking place, and the plaintiff might allege that the school district failed to properly supervise the young people that were on the school grounds that evening for the prom. And I didn't give you much information about the source of the alcohol, but I think we'd all agree somewhere along the line there had to be an adult involved in facilitating these young people getting alcohol, whether it was the store clerk who didn't card them or whether it was one of the family members of the young people who provided the alcohol. There needed to be kind of an adult that facilitated that process. One other thing to note, and maybe someone mentioned it, but is that these defendants may file or may have filed, I believe it would be called a countersuit against Sally. And the argument would be Sally was aware that Joe was drinking, yet she assumed some risk by getting into the vehicle with him. And really what she should have done, and I'm speaking of what the parties that would file this countersuit would argue, they would argue that she should have called mom and dad to come and get her and take her home or ride home with another couple from the prom, something like that, that she assumed some risk by getting into the vehicle with an individual that she knew had been drinking. So you can see this kind of what may seem like a simple scenario can actually get pretty complex kind of quickly given all the legal matters involved. But I thought that was kind of maybe a good way to kick off things to show potential liability of different defendants in this case, a kind of a tree fall case, we would call it. And we'll talk about vegetation and trees. In fact, in the law, there is a whole category of cases. I believe the plaintiff's attorneys call them hazard tree cases, which do involve tree falls or limbs or branches falling from trees, or trees that fall onto vehicles versus trees that fall and then a vehicle runs into the tree. So it's a whole recognized category of the law. So with that as background, let's get into talking about tort liability. I think everyone probably has a feel for what liability means, but maybe not so much tort. So what is a tort, or what is tort liability? And here are some of the elements in the definition of a tort. Notice it's a civil wrong that results in injury or damage to someone or something. And so what do I mean by civil wrong? In our legal system, kind of two major divisions or categories within the legal system are the criminal side of things, and then also what the attorneys and judges call the civil side. And so a tort falls within the civil division of the legal system or the court system. So it's not a crime, but it falls within, it's a wrong that resulted in injury or damage. So it would be tried in the civil division or branch of the legal system. Also note it's independent of a contract. Many of you with public agencies may be involved in lawsuits involving a contractor or subcontractor or something like that. And those are certainly important aspects, important cases, but that would fall under contract law. That is not a tort. The other thing about a tort that maybe folks haven't thought about is that a tort is a violation of a duty owed to the injured party. So what is the duty of a road agency and the road agency employees, let's say, to the traveling public? And we'll look at that here in a minute, but first I want to share with you an example of a situation that led to tort claims. This was a fatal crash, sadly. It happened on this two-lane, two-way rural road. This is an after the incident photo, some months after. It was not taken at the scene, but you'll notice, I'll get my cursor here. There we go. Notice this is about an 11-inch high, almost vertical edge of pavement drop off along this roadway. And what happened, an empty coal truck was coming from the back of the image toward us. And for some reason, the vehicle's right tires left the roadway and ended up on the shoulder of this roadway, this unpaved shoulder. And as often happens in these cases, the first kind of instinctive reaction by the driver is to steer the steering wheel sharply to the left to try to get back on the pavement. But what happens also is, because of this significant edge drop off, the wheels do not immediately regain the pavement. So the driver kind of yanks the wheel harder to the left, and eventually the steering angle is such that the tires regain the pavement. But what often happens in that case is that by that point, the vehicle is in an out of control yaw, as it's called, YAW. And the vehicle either goes across the roadway onto the opposite roadside, or the vehicle may strike an oncoming vehicle. And unfortunately, that's what happened here. Here you can see the scene photo taken shortly after the crash. And notice I mentioned the yaw marks, YAW. Here you can see those yaw marks, the curved marks, sometimes called oversteering, overcorrection sort of marks. So that vehicle, that truck, was out of control as it went across the roadway. And unfortunately, what you see here is what's left of a Chevrolet SUV that was at the wrong place at the wrong time. It was being driven by a 32-year-old mom taking her 8-year-old son to school. Tragically, she was killed in the crash. Her son survived, but obviously was traumatized by what happened. And her surviving husband filed several tort claims. He filed a tort claim against the truck driver, alleging negligent operation of the truck, failure to keep the truck under control. He filed a tort claim against the trucking company, alleging negligent hiring of the operator. They should have never hired such an unqualified operator, using their words. There were also potentially some issues with maintenance of the truck's steering system and braking system. And so the tort claim alleged those things, deficiencies in truck maintenance. The truck was hauling coal for a coal company, a mining company. As I mentioned, it was empty at the time. It had dropped off its load, but the coal company was also sued as part of this incident. And then, of course, we have the roadway that you see here in the photo. This happens to be a state roadway, and so a lawsuit was filed against the state DOT, alleging negligent maintenance of the roadway, specifically the low shoulder condition and the edge of pavement drop off. So that's an example of a tort claim, or in this case, multiple tort claims. There was injury or harm. A person was fatally injured and another person suffered both physical and maybe emotional trauma in the case. And there, in all cases, it was alleged that there was a violation of the duty on the part of the defendant. So what is a duty? We're not going to look at all these defendants, but I think we're here to look at it from the roadway agency perspective. What is the duty of a road agency and the road agency employees? So the primary duty is to provide reasonably safe roads. I think that's true in virtually every state in the United States. The legal duty in the state law is to provide reasonably safe roads. Now, some of you might be thinking, Ron, that's kind of a nebulous statement there. That really doesn't help me do my job any better. What's reasonable or not, or what's reasonably safe? And I agree that is kind of nebulous. And ultimately, if you think about it, it would be a jury. If a case went to trial in the courtroom, it would be the jury that would make the decision of whether something was reasonably safe or not. But I ask you to think about what this doesn't say. Notice it doesn't say that we have to provide accident-free roads. It doesn't say we have to ensure the safety of the road user or guarantee the safety of the road user. We just have to provide reasonably safe roads. So the legal system recognizes crashes are going to happen, and the road agency's duty is to provide reasonably safe roads. And hopefully after we get through this topic over the next 3 days, hopefully you'll have a better feel for what would be reasonably safe or not reasonably safe. But now there's times when maybe we can't provide a reasonably safe road. Maybe due to like here where I am in West Virginia, a lot of our roads, our secondary type roads, were never really designed. They just evolved from animal paths or Native American Indian trails. And then they maybe at some point got a stone surface, and then they were widened a little bit as vehicles got bigger. And then maybe a hard surface, asphalt surface was placed. But since it never was designed, quote designed, there's, some of the curves don't comply with modern standards. The gradients may be steeper than modern standards call for. The width of the roadway may not be as wide as we'd like. So how do we handle those situations where it could be argued we don't have the funds to upgrade all of those thousands or tens of thousands of miles of roads that don't comply with current design criteria? So the secondary duty of a road agency is to warn of existing hazards. So that's why on roads in many parts of the country, say in hilly or mountainous terrain, you will see curve warning signs with advisory speeds. You'll see signs warning of steep grades or long grades, long and steep grades, those sorts of things. So where we can't provide reasonably safe roads, the duty is to warn drivers of existing hazards, if you will. Or I guess we could say maybe even temporary traffic control falls into that situation. In a work zone, the roadway width may be narrower than normal. The surface may be milled for some time, and so it's not the normal driving surface that motorists come to expect. There may be lane shifts, but of course, we warn drivers of those things through the orange and black warning signs associated with temporary traffic control. And then there's kind of an ongoing duty, if you will, to provide reasonable and continuing supervision over roads and streets so that the agency is aware of the roadway condition and possible defects. So that's another duty. It's kind of an ongoing duty, but the courts expect that road agencies are aware of the condition generally of their roadways. And we'll talk more about that as we go through here as well. So those are the duties, legal duties of a road agency. And I did want to mention we won't talk much about it this week, but another type of claim that is faced by state and local governments deals with inaccessible sidewalks and streets, or is related to the Americans with Disabilities Act. And these types of suits, they're important, they're significant, but they do not fall under tort law. They fall under civil rights law. So let's look kind of briefly, torts versus civil rights. In a tort case, remember we talked about someone has suffered injury or harm, and the liability is based on proof of that harm and trying to show that the defendant, the road agency, failed to provide a reasonably safe roadway. And in a tort claim, the plaintiff is seeking compensation for the harm, compensation for their injuries, property damage, and so forth. So those are tort claims, would fall under this category, which is what we're going to focus on this week. But in a civil rights claim, or an equality case, I guess we would call it, like an ADA related lawsuit, there the objective is to ensure equality in access to public services, programs, and activities. And what the plaintiff is seeking is not compensation. They're seeking to have the barrier removed. Remove that barrier so I, who might be an individual in a wheelchair, so I can get to my workplace, or I can get to shopping, a shopping destination, or to the library, whatever it might be. And so the civil rights claims need to show differential or disparate treatment, meaning less or no access to a particular, say, destination. And here's an example in the image here. Notice you can see in the foreground is a sidewalk, and then we see a signal pole. And if you look closely where my cursor is, we can see there's a push button here. But notice if someone is in a wheelchair or using a walker or maybe other assistive device, or even if you're able-bodied, it's probably difficult to reach this push button given the grass surface with kind of briars or shrubs here. And so this would be the type of situation that could pose an ADA claim or lawsuit risk to a road agency. And in this case, the claim would be failure to provide an accessible push button at the corner here. So I wanted to mention that because it is a significant legal exposure for public agencies, but it is a civil rights claim, not a tort claim. And we may mention it from time to time throughout the next few days, but our focus is going to be on tort claims rather than civil rights claims. I mentioned there'd be a few legal terms as we go through here, and here is one legal term, the standard of care. What is the standard of care? The standard of care is defined as the criteria by which reasonableness is judged. So standard of care is the criteria by which reasonableness is judged. And can be a number of different standards of care. This is really just a few general examples. I'm going to actually start with the second bullet here. Guidelines developed by national and professional organizations. One that I think many, maybe most of you are probably familiar with, you may use it every day, is the Manual on Uniform Traffic Control Devices, the MUTCD, issued by the Federal Highway Administration. That would be considered, and it's adopted by each state, either in the form of the FHWA manual, or states may adopt their own versions, which are in substantial conformance with the national MUTCD. But the MUTCD, whether it's state or the national one, would be considered the standard of care when it comes to signing and marking roads and streets that are open to public travel. Another one that those of you that may be involved in design are familiar with the American Association of State Highway and Transportation Officials, AASHTO, their policy on geometric design of highways and streets, also called the Green Book. That contains highway design guidance and would be considered in the United States as a standard of care when it comes to designing roads and streets. So those are two examples of roadway related guidelines developed by national and professional organizations that would be considered standards of care. But of course, each of your agencies, those of you with public agencies, each of you has your own, they may have different names, you may call them guidelines, regulations, directives, policies, maybe even different names from these four. But each agency has its own guidelines that it follows when it comes to roadways, whether it's road design or construction or maintenance or operation. And those agency guidelines then for that specific agency become a standard of care. So it's important that we follow not only national sort of guidelines, but agencies need to follow their own guidelines. And so that's why it's important, we'll talk about it probably tomorrow, it's important to make sure your policies and guidelines and directives and things are up to date and reflect current practice. And of course, the agency then needs to follow those. Or another standard of care could be directives issued by a superior agency. There's a variety of different things that could occur here. Notice the last one on my list, engineering texts and journals, and I put a couple asterisks there because this is maybe a gray area. I think there could be some cases where engineering textbooks and journal articles on a particular topic could be considered to be a standard of care, but probably in most cases, road agencies probably don't follow on a daily basis things that might appear in journal articles or in engineering textbooks. So I like to talk about, I think I may have used the term already once before in my opening. It's important, I think, that road agencies, the employees and the attorneys, when a case goes to trial, it's important that we educate the jury about road agency practices, how we work, what constraints we face, that sort of thing. And so this would be an example of that, because sometimes a plaintiff's attorney and their expert witnesses may try to convince the jury that some article that appeared in a technical journal or in an engineering textbook is the standard of care. And like I said, there may be cases where that's true, but I think in most cases, those sorts of sources are not really standards of care for road agencies. So it's important for the road agency to kind of make that distinction to the jury. As you might suspect, the element of time plays a big role in these cases. And here are two more legal terms: notice, also referred to as actual notice, and constructive notice. So what is each of these, or what's involved here? Actual notice means that the public agency, the county or the town or the city or the state, was given specific notice about a defect in the roadway system. And someone may have made a phone call, they may have responded on the agency website, they may have sent an email, they may have sent a letter to the agency advising them or complaining about some problem or some deficiency. And so those phone calls, those emails, those letters, those are considered notice and sort of starts the clock running of how long did it take the agency to begin to respond to that complaint or that concern or that notice. Another thing that the courts have indicated can also be considered notice are things like an editorial in a newspaper that may, for example, maybe one day the newspaper column talks about a curve in the county that has had a number of wet weather crashes, and they may talk about, something needs to be done to reduce the crashes in this curve every time it rains. You might say, well, that's not actually formal notice to the road agency. No one specifically told them about it, but I think the courts would say, given where that occurred, kind of in the media, in the public forum, if you will, that the road agency should have been aware of that, the comments about and concerns about that curve in the case of my example. So these would be examples of forms of notice to a road agency. So what's constructive notice? Constructive notice is actually stricter than notice. With notice, another way of looking at notice, and what the plaintiff's attorney would say in the courtroom, is they would say the road agency knew about this drainage problem because they received 4 emails about it. So they would say the road agency knew.
Hey, Ron.
Yeah.
Question that's kind of timely right there. Someone wanted to know, what about Facebook rants about bad spots on roadways?
Yeah, that's a good question. I would say if it's happening on the, on the agency's social media, then it would be argued that the agency should be aware of that. But if it's happening just, some private group is ranting about an issue, and this is Ron's engineering opinion, I would say I would not really call that notice. To me, the public agency doesn't need to be monitoring, many different Facebook groups or Facebook pages. But if that rant is on the agency's social media, then to me that would be a different story. Then they should be aware of that. But otherwise, probably not so much, at least in my engineering opinion. Good question. So constructive notice is stricter, and it says after a reasonable time, even though no one may have told the agency, a prudent agency should have been aware of the defect. Or another way of stating constructive notice is that the agency should have known. Even though no one told them explicitly, the agency should have known. And I list some examples here. Notice the last bullet there is a 3-month-old down stop sign. And so notice, I think we'd all agree this is not a good situation, right? We have I would call it a right-of-way safety critical sign. A stop sign is face down in the ditch. And if I told you that had been there for 3 months and nothing had been done about it, I think maybe we'd all agree that a prudent agency should have known that that stop sign got knocked down. If nothing else, there should be like law enforcement or EMS personnel or maintenance employees of that road agency passing through this intersection that should have detected that sign and taken steps to put it back up in the proper position like it was originally. But that's 3 months. What if I took that photograph 2 hours after the stop sign was knocked down? Then it gets to be maybe sort of context specific. If this happened in a rural area in the middle of the night, it may be several hours before there'd be traffic on that roadway if it's a very sparsely populated area. And even once the agency identifies it, they can't probably fix it immediately. They need to mobilize a crew, get the materials together, get those into the truck, and then travel to the location. And so again, it gets into maybe educating the jury about how we do business, how our procedures operate, because it may be that because the agency couldn't respond in a couple hours, that may be reasonable under the circumstances. But then we'd look at, are there other things that could have been done? If it's a major intersection, maybe law enforcement needed to be stationed there to provide temporary traffic control, or maybe a temporary stop sign installed until the permanent one could be re-erected, those kinds of things. So I think you can see that it can get complicated, but it's important, again, as I keep saying, to be able to educate the jury of how the road agency operates, what our procedures are, what would be a reasonable response time for this situation. But certainly a down stop sign should be a top priority in terms of getting that back in proper position. I will ask for questions at this point. If anyone has questions, feel free to type them in the chat and Victoria will interrupt me. The next item I wanted to look at is the elements necessary for a tort action to proceed to trial. And notice I carefully worded that. I didn't say that these are the elements necessary for a plaintiff to win their case. It's things that are needed that the plaintiff has to prove for a tort claim to proceed to trial. And if we were like a fly on the wall in a place like a restaurant or a pub or a club maybe where personal injury attorneys hung out, what we'd hear them talk about, what you hear them say is they say, I just want to get my case to the jury. I just want to get to the courtroom, because they're confident enough in their ability as an attorney and confident that they have a sympathetic plaintiff that if they can get to the courtroom, they can convince a jury to award a large sum of money to their client. And so they want to get to the courtroom. But to do that, there's 4 things they have to prove. And I want to spend a few minutes talking about that because this is kind of an important slide. And the significance is if we can show, or if the defendant road agency can show that any one of these are not true, there's a good chance that the case might be dismissed in what's called a motion for summary judgment. So let's look at each of these. So we'll start with number 1. And notice the plaintiff has to prove that the defendant had a duty to the plaintiff. And based on what I mentioned a few minutes ago, in roadway cases involving public roadways, this is a given. We can't really get around this one. Public agencies, as I mentioned a few minutes ago, have a duty to the traveling public, and that duty is to provide reasonably safe roads or to warn motorists about any hazards. So number 1 is a given, but the plaintiff has to prove that the defendant had a duty to the plaintiff. Second one is the plaintiff has to show that the defendant breached that duty. There's another legal term, breached. Basically, that to restate this, the plaintiff has to show that the defendant failed to follow the relevant standard of care. The defendant failed to follow the relevant standard of care.
Hey, Ron,
Yes,
speaking
ma'am.
of relevant standard of care, someone asked, must you have physical damage? What if you saw the down stop sign for 2 months, nothing was done? However, you reported it and nothing was done.
I assume that means the opening comment meant there was no crash at the intersection either.
That's what it sounds like. That is just, Good Samaritan saw the stop sign was down, reported it, and is now irritated because it wasn't handled.
Yeah, I guess it's just sort of good luck that maybe there was no crash at the intersection. So if there was no injury or no harm, there would be no lawsuit, or no legitimate lawsuit. But yeah, that would not be a good situation because it sounds like the agency ignored notice that was actually being given to them. And if there was a crash, maybe weeks or months after that notice was given, that would not be a good situation for that road agency. I don't know how that explained or justify their inaction.
Right.
So
And
once notice comes in, we should try to respond to that as quickly as possible, especially if it involves a stop sign.
got another question here, and I take it this must be a hypothetical. What about having roads located without a railing along a cliff? The agency does not have funds to install a railing. If there's a crash, is the agency at fault? And they said in this hypothetical that it's been this way for years.
Good question. Can I delay that? Because we will talk about that specific kind of barriers or guardrail sort of issue. So if you don't mind, we'll delay that. And if I don't answer it completely at that time, feel free to holler at me. But we
All
will.
right, that's it for now.
Okay. The third thing the plaintiff has to prove is that they suffered damage. Now, in a lot of course, motor vehicle cases, there's going to be serious damage because we have large, mostly metal vehicles traveling at relatively high speed. And if they strike each other or strike a tree, or strike a guardrail, or strike a bridge pier, there's going to be a lot of kinetic energy dissipated and probably a lot of harm in terms of injury to the occupants of the vehicle or to a pedestrian that might be struck. And so in many roadway cases, this is kind of a given. It's not difficult to prove that there was damage. But there is a category of cases, I believe the personal injury attorneys call them soft tissue cases, where someone is alleging they suffered damage, but there's no kind of obvious physical evidence. For example, maybe a whiplash type of neck injury or other sorts of similar related injuries. There may be no obvious damage that could be shown, say, to a jury, but yet it may be that that person has certainly suffered harm. I don't mean to minimize that. So interestingly, a case involving these types of injuries may get down more to, rather than technical testimony about, say, the type of sign to be used or whether guardrails should have been installed, it may get down to which physician or which doctor does the jury believe? Do they believe the plaintiff's physician who's alleging all this harm, or do they believe the roadway agency physician? And the roadway agency attorney likely would retain the services of a physician, an independent kind of medical evaluator, to examine the plaintiff and look at their medical history. And they may render an opinion that, no, this individual did not suffer damage in the crash. And so then it's a question of which physician does the jury believe. The fourth thing the plaintiff has to prove, and this can be a significant one, is the plaintiff has to prove that the failure to follow the standard of care was a proximate cause of the damage. And here's another legal term, proximate cause. You might think of that as a direct cause. Was the failure to follow the standard of care a direct cause of the damage, of the injury, of the harm? And sometimes, and I have an example here I'll show you, sometimes a road agency can show that, yeah, we failed to follow the standard of care. We should have done this or done that. But our failure to do that had nothing to do with the crash. And so let's look at an example. And I'm not going to identify where this is. It's not in West Virginia or Ohio. It is in the northeastern United States. It's a very small, sparsely populated rural jurisdiction. Very small population. In fact, the road agency doesn't even have full-time employees. They just have 2 part-time employees. They call them road supervisors. And I say that just to show that this is a very small agency. And in fact, as I mentioned, these road supervisors are part-time individuals. One, I think, is a plumber in his full-time work. And I don't mean that in any negative way, but just to show that that individual really had no background in construction or roadways or road maintenance or that sort of thing. The second road supervisor was a much younger individual, and he was an insurance agent. He did not have any background in roads or construction or maintenance either. But the one thing that sort of set him apart was that he was eager to learn more about roadways. In fact, in his state, the LTAP program had a Rhodes Scholar program, like many LTAP centers do, and he actually was a Rhodes Scholar. He'd been to a lot of roadway-related training. He'd been to road safety classes. He'd actually been to a class similar to this one on risk management. So I give that background because I think that's relevant to the story here. But one night, there was a vehicle ran off the road and struck a tree. And there were two young males, they were not related, two young males in the car, and they were both fatally injured in the crash. And the road supervisor heard about that during the night, and when he got to his workplace the next morning, and this was the younger road supervisor, the first thing he did was he said, I need a copy of the police report. If two young people died, there's a good chance that we may have one or two lawsuits filed against the agency. So I'd like to see the police report. So he got an advance copy of the police report, and I won't go into all the police report, but this was the drawing that was on the police report. With all due respect to the law enforcement, I'm not sure this is a great drawing. Notice it doesn't even give any location reference. It doesn't give a utility pole or an intersection or a house number or anything like that. But anyway, this young road supervisor knew where the crash occurred. And he noted that the police officer included two curved marks across the roadway. And based on his LTAP training, as we've talked about here, he realized those were yaw marks that could be associated with an edge of pavement drop-off condition. And then he got further concerned when he saw that the police officer, the investigating officer, just wrote here at the bottom of his sketch, 8-inch edge drop-off. And he also knew from his training that an 8-inch edge drop-off is probably not a reasonably safe roadway condition. But he also knew that when a vehicle goes off the road in a drop-off condition or situation like this, and I think I mentioned this earlier, the tires, the inside of the right tires will scuff up against that vertical drop-off until the tire regains the pavement. So he thought to himself, he said, that if the vehicle actually encountered that drop-off, there should be scrub marks or scuff marks on the inside of the right tires. So he went to the police and said, I'd like permission to go to the impound yard to inspect this vehicle. And so they granted him permission. So he went to the impound yard. But first he went to the site, I should note. He went to the site, and this is what he found. Notice it's about an 8-inch high vertical edge drop off, and not a good situation. But what he found is that drop off was here toward the right side of the sketch. And he thought to himself, it may be this vehicle never reached the edge of pavement drop off. For some other reason, the driver steered sharply to the left. Maybe there was a deer in the roadway or something like that. And so again, that's why he wanted to inspect the vehicle. And this is what he found. I'm not sure this is the right tire, but it doesn't matter. He looked at all 4 tires, and notice there is some grass and some mud here because this vehicle went off the roadway. But he did not see, and I don't see here, any scuff mark or scrub mark to suggest that this vehicle scrubbed up against a vertical edge of pavement drop off. And so he included all the photographs he took at the site and of the vehicle inspection, his notes, measurements he'd made at the site, and he just basically filed those away and didn't think too much of it till about a year later. Sure enough, 2 lawsuits were filed, one each by families of the 2 people, 2 young men killed in this crash, and they alleged negligent maintenance of the roadway and allowing a unreasonably safe 8-inch high edge of pavement drop off to exist. The case went through the tort claims process, which we'll talk about here probably today or tomorrow. And they went through the discovery process, depositions were taken, information was shared between the parties. And then at that point, the attorney for the road agency filed a motion for summary judgment. And basically, in a nutshell, the motion said, Your Honor, this was a tragic case. The road agency, we did fail in our duty to provide a reasonably safe road. We had an 8-inch drop off on the roadway, but the evidence, the physical evidence shows that the vehicle never reached that edge of pavement drop off. For some unknown reason, this vehicle left the roadway and struck the tree, and the edge of pavement drop off had nothing to do with it. So the breach of the duty was not a direct cause of the crash, and therefore you need to dismiss the case because the plaintiff has not met their burden of showing that the breach of the duty was a direct cause of the crash. And I think the physical evidence was so overwhelming that the judge had to agree, and so the judge dismissed the case. And I think that's certainly, there was some expense and time involved going through the discovery process and so forth. But I think this young supervisor's actions in doing a little bit of kind of extra investigation above and beyond what law enforcement did helped his agency have a case dismissed, and so that it never went to trial. So that's an example of how an agency can kind of maybe take advantage of showing that one of those things that the plaintiff, 4 things that the plaintiff has to prove, if we can prove one of them is not true or doesn't apply here, the case may very well be dismissed. Another legal term, I think most of you have probably heard this, is the term negligence. And negligence is the most common tort claim against road agencies. But I did want to make sure I stated the definition of negligence, because sometimes I think folks have the idea that negligence is just failing to do something. But negligence can be more than that. So notice, negligence is the failure to use the standard of care expected of a reasonable and prudent person in a particular set of circumstances. So negligence is not only failing to do something, negligence could be doing something that a reasonable person would not do. So it's not only kind of inaction, negligence could also be action if it's something that a reasonable person would not do. I wanted to say a few words about what are called tort claims acts. Each state has a tort claims act. They may go by different names in particular states, but I think most of them call them Tort Claims Act, and they are passed by that state's legislature. And tort claims acts define the type and nature of claims and suits that can be brought against state and local road agencies. So they define the type and nature of claims that can be brought against state and local road agencies. So obviously they're pretty important, but they're probably of more significance maybe to attorneys rather than road agency employees. But I did want to at least give kind of an overview of some of the things that are covered in a tort claims Act. And one of those is immunities and what are called exceptions to immunities. And I think we're all familiar with the term immunities kind of from the medical and health perspective in terms of immunity from maybe certain diseases or that sort of thing. But in the law, basically, if an agency is immune from suit or has immunity, it basically means they cannot be sued for a particular type of, in a particular type of claim. And of course, then exception to immunity would be important because it means that the agency can be sued for a particular matter. And these, of course, vary from state to state. Each state has slightly different Tort Claims Act and may have different immunities. And in fact, the immunities may vary even between state and local agencies in some states. And this may cause attorneys to try and utilize different strategies and tactics to either pursue or to defend a case. And here's an example. I call this the design versus maintenance versus warnings. I'm not sure what state this is, but I think you can see they're using the symbolic kind of falling rock sign to alert motorists that there's the potential for falling rock along this section of road, which looks like the road has been, it's going through kind of a cut section here where the road is lower than the surrounding terrain. And actually, I don't really even see any rock. It looks like more of a sandy kind of soil, but still, let's imagine there's material falling off of that slope. And let's imagine a case where, let's say the slope is much higher. Maybe there's actually significant rocks or boulders. And one day a semi truck, an 18-wheeler, is driving down the roadway here, and a large boulder comes off the slope and actually strikes the top of the cab of the truck and goes through the roof and seriously injures the driver. And the driver files a lawsuit against the road agency. And let's say the attorney that this truck driver retained, let's say they file a claim alleging negligent design of the roadway. And that's what caused the rock to dislodge and to strike the vehicle. And let's further imagine that this is a state where design is immune from suit. There are states where design is immune. Claims cannot be brought for design deficiencies. And let's say this is one of those states. So the claim would come into, say, the legal department of the DOT, and probably the first thing the road agency attorney would do is say, how can we defend this case? They're alleging design deficiency, but, or I'm sorry, maybe they allege negligent maintenance. Let's say the plaintiff alleges negligent maintenance. Sorry about that. So when it comes into the DOT attorney might say, this is not a maintenance case, this is a design case. We could have designed this roadside with much flatter slopes so that no rocks would reach the roadway. But that would have required movement of hundreds of thousands of cubic yards of earth and rock, would have required additional right-of-way, and it was a design decision to design the roadway this way rather than with flatter slopes. So design is immune, so therefore this case should be dismissed. I'm not sure the courts would buy that argument myself. I think the case would probably be allowed to proceed, but that's an example of sort of the tactics or strategies that plaintiffs' attorneys and defense attorneys can use in these cases. The road agency might also argue, I'm not sure it would make sense, but they could also argue we didn't know there had been no prior rock falls on this slope. We didn't know about it, but the evidence shows otherwise. Notice there is a warning sign, so the plaintiff could argue you were certainly aware of the potential for rocks to fall here because you placed a warning sign advising motorists. Another thing that's covered in the Tort Claims Act are defenses to liability. And there's two main types of defenses to liability, what's called contributory negligence and then what's called comparative negligence. And since comparative negligence is by far the more common, let's look at that first. So comparative negligence says a party can collect weighted damages for their comparative negligence. So with the jury, when they're working up their verdict sheet, they have to assign responsibility to the various parties in the lawsuit, the plaintiff and defendants, and that needs to add up to 100%. If the jury finds that the plaintiff is 1 to 50% negligent, the plaintiff collects weighted damages. If the jury finds that the plaintiff is greater than 50% negligent, the plaintiff does not collect anything. So let me give a simple example, maybe a couple examples. One, let's imagine I'm a plaintiff in a roadway case. Let's say my vehicle went off the road in a curve and I was very seriously injured and I file a lawsuit. And then it comes to light during the testimony and trial at the courtroom that the evidence seemed to suggest that I was texting as I was rounding this curve. So let's say the jury decides to award me $3 million, or decides the award is $3 million. But they say, Ron, you were 25, or let's say 30% negligent because you were texting. You shouldn't have been texting as you went around this sharp curve. So I don't get $3 million. I get that reduced by 30%, which would be what? $900,000, I guess. So I would get $2.1 million. I would not get the full $3 million verdict because of my negligence. But now let's imagine same sort of case, but maybe there not only was I texting, but maybe evidence was introduced to show that I was impaired, that I had alcohol in my blood. And in that case, the jury might say, we find you 75% negligent because you were texting and you were impaired. And so in that case, because my negligence exceeds 50%, I would not collect anything. So that's how comparative negligence works. And most states in the United States are comparative negligence states. There are a few states, 4 I guess you can see listed there, that are contributory negligence states. Contributory negligence says a party cannot collect damages if their negligence, even if as little as 1%, contributed to the crash. So think about that. That's a pretty strict bar, pretty high bar. I mean, I think like most people, I like to think of myself as a pretty safe driver, but probably if I was in a crash, someone could show that maybe my windshield was dirty or I hadn't had my headlights aimed in many, many years. And so they might say that I was 1% negligent, in which case I would not be able to collect damages. So that's the difference between contributory and comparative negligence.
Ron, I didn't want to interrupt that explanation, but we had a question that came in about the falling rock, right, as you moved into this next topic. So the question is, falling rock is one thing, but what if this hillside becomes a landslide and cars are hit and injuries are sustained?
Yeah, that's a good question. And actually where I am in West Virginia and probably Southeast Ohio may be similar. I mean, that is not an unusual situation. We have many of those probably in a given year. And not to evade the question, but I think a lot of it depends on the specific situation. Like, what evidence would there have been? And oftentimes, and I'm not a geotechnical engineer, but oftentimes, as I understand it, in those types of, say, landslide or land movement situations, there may be evidence ahead of time of maybe water flowing out of cracks or some other types of movement taking place. So I think it would depend on what that sort of evidence was and how visible it was in terms of, should that have been noticed to the agency that they should have known about it and therefore done something about the landslide or the slip that was occurring. But no, those can be serious and also very interesting cases, because they probably, more so than, say, a traffic engineer or a roadway engineer, they may involve, probably do involve, geotechnical engineering, where you get into analysis of slip or slide potential and subsurface geology and subsurface drainage and those sorts of things. But in many parts of the country, as I said, those are and can be significant types of claims, and not unusual claims.
Thanks, Ron.
Good question. So what do you need to know? I would just say, I know we have folks from different states here. Try to become familiar with the Tort Claims Act in your state. And you can read it, of course, but since these are written by attorneys, oftentimes they're in legalese. Maybe the best thing to do would be try to schedule a meeting with your agency attorney and just sit down for an hour or so and have him or her give you a good overview in normal language of what the Tort Claims Act involves and how it affects road agencies. And recognize that these Tort Claims Act do change. They are products of state legislatures, and so they're going to change over time. Many of you have probably heard the term tort reform. What that basically means is revising or changing or updating states' tort claims acts. And so recognize that they do change over time as composition of legislatures change over time. One more legal term, maybe the biggest legal term we've talked about, subsequent remedial measure. Subsequent remedial measure. And here's the legal definition. When measures are taken that would have made the injury or the harm less likely to occur, evidence of remedial measures is not admissible to prove negligence or a defect in design or the need for a warning. So think subsequent means kind of after the fact. Remedial means what? Corrective action. So this is referring to corrective actions taken after the fact. And maybe some of you have been in this situation, because I know many of you maybe respond to serious crashes in terms of traffic control or other public works involvement at a crash scene. And maybe you've come upon a crash, serious crash, the emergency responders are there, and maybe it was at an intersection, and you're just arriving there and you look at it and you think, oh man, that tree branch maybe was obscuring that stop sign. That we should have trimmed or pruned that tree branch to prevent that visual obstruction of the stop sign. And then sometimes I've heard people say to me in that case, but I'm not going to do anything, because if I cut that tree branch that's blocking the stop sign, that's going to be an admission that we were guilty or that there was a problem and we corrected it right after the crash. That's actually not good thinking, because of this concept of subsequent remedial measures, which is there to promote safety. So if you ever see that situation where after a crash, you go to the scene and maybe we should have fixed that drainage or trimmed that brush or whatever it might be. You shouldn't hesitate to do that, because this concept of subsequent remedial measures says that the fact that you corrected the situation is not admissible to prove negligence. So the jury would never know about it in the courtroom. And so that's an important kind of legal concept there, that subsequent remedial measures. And we may look at an example or two on Thursday in some of our case studies where that's the case. So any questions on tort liability? There were a lot of legal terms there. I appreciate that. But I think that was necessary to understand what tort liability is and some of the different aspects of it. We also talked about the 4 things that a plaintiff has to prove to get their case to the courtroom.
Ron, there is one question.
Sure.
They'd like to know, do plaintiff attorneys ever attempt to cite remedial measures in court to sway a jury?
Oh, yeah. Oh, yeah. Yeah, and I mean, it can happen in a number of ways, but yeah, they will try to do that. And it's an interesting, I'm not sure, I'm trying to think of what the term might be. I don't want to say cat and mouse kind of strategies, but it gets interesting. I know a few years ago, I had a case. I was retained by the road agency. It was a stop controlled intersection, and it had a history actually of left turn related crashes, vehicles making a left turn at the intersection and then were struck by vehicles on the through roadway. And like I said, it had a history of those crashes. And so within about a month after the crash that led, it was a fatal crash that led to a lawsuit. Within a month after that fatal crash, the road agency put up or signalized the intersection, put up traffic signals. And by the time I got involved, which was maybe a year after the crash, when the lawsuit was filed, by the time I got to inspect the site, the intersection was signalized. So all of my photographs were of a signalized intersection. And so actually the judge would not allow my photographs to be introduced to the jury, because he said this will bias the jury because it shows the subsequent remedial measure. But in other cases, I've seen plaintiffs' attorneys, bring it up in the courtroom, maybe on questioning of witnesses. And then of course the road agency attorneys will object, and the judge might say, the jury is instructed to ignore that response or something like that. But of course, to me as an engineer rather than an attorney, to me, kind of the damage has been done. The jury is aware of that. So yeah, those sorts of things do come up, and it's a lot of times a question of how the judge addresses or deals with those statements or those questions that come up. Again, it's going to vary from judge to judge. I was involved in one case many years ago. I don't think I'll talk about this one on Thursday, but after another intersection crash, and a few months after actually was a triple fatality at the intersection, the road agency put in rumble strips on the stop controlled approach to the intersection. And they were going through, they had, all the depositions and discovery were done, and the parties were getting ready to go to trial. And at the pretrial hearing, the judge just happened to say, I think I'm going to let the jury know that rumble strips were installed here, which flies in the face of what I just told you all, because typically subsequent remedial measures are not admissible. But whatever reason, this judge said he was going to do it. And when that happened, the road agency attorney, the road agency offered some money to settle the case. So on these sorts of things, a lot hinges on kind of the judge and what their statements or what their kind of attitude or policy is on these things. That's why I can't give you a definitive answer to your question.
there's a comment that came in. This individual said they had 3 intersections that were in the design phase going to contract phase for adding signals that had had major crashes. Looked like we, quotation marks, put up a signal in response when it had already been in the works prior based on previous traffic crash patterns. And then there's a question that says, here, let me pull this down a little bit because it's a pretty long one.
Before you ask that,
Sure.
Victoria, could I just respond to the comment? I mean,
Yeah.
I agree with that comment, and that I think kind of supports what I was been saying earlier about the need to educate the jury. You need that, the fact that, you know, these intersections were in the pipeline to be corrected, you know, for some time. That needs to me to be brought out through questioning by the agency attorney of the road agency employees, because that's important, and that shows that, you know, the agency was being proactive, they were addressing this, and so to me that's part of that educating the jury thing that I've been talking about. Sorry, go ahead.
No, you're good. It gave me some time to read through this next question, and I think we're going to see some nuances here concerning Ohio workers' compensation law in this question, which I, you know, don't know if we, you know, adequately warned you about also preparing for workers' compensation law, Ron. So if you need to get back with this person or I need to do some digging, I'll do that. But the question is, most of your review focuses on the general public sustaining damage. Will you speak about tort liability as it relates to a contractor's worker completing work on a contracted project? Specifically, if a worker is hurt during construction, if the public agency holds tort liability. Additionally, how does the agency being on site and not enforcing parts of the contract, or if OSHA regulations were not in compliance during the accident?
Yeah, great question, and I have to admit I will not be addressing those topics in this session. This will basically address, you know, the tort from the perspective of the public, motoring public filing claims against road agencies. And yeah, I would have to do some looking into that. Victoria, I don't know if, since being from Ohio, if you're able to address any of that, or if not,
Yeah.
that's too.
I'll reach out to the individual. No worries there.
Okay, thanks.
Next question, and then I know you'll probably have to move on. Is there typically an understanding from the judge if a project is budgeted to be completed in so many years? Say a study found X needs addressed, and you have it budgeted to be completed next year, and then there was a crash that was the result of that item that was budgeted to be fixed next year.
Yeah, good question, and I'm not sure I even have much experience with judges thinking on that, on those sorts of issues. But to me, again, that would relate to kind of that, in this case, maybe not only educating the jury, but also sort of educating the judge, the trier of fact, if there were things that came up that caused the project to you know, schedule to change or lag or that sort of thing. Again, that would be, and if they were, of course, I suspect there are valid reasons for that, that would, to me, need to be brought out to the judge and to the jury.
That's why these cases all depend.
That's right. That's right.
It depends.
Like I say in my ADA classes, the answer often is it depends on the specific context. And same is true in these cases. It really depends on the specific situation.
Thanks, Ron.
And thank you all for those good questions. Now let's shift gears a little bit and look at some common problem areas. And those of you following along with the handout, this is sort of where this part of the handout ends, just for reasons of space and other reasons, or file size and other reasons. I've not included all the photographs that I'll be showing, but these are some areas where claims or tort suits are are maybe not common, but do occur, and so I'd like to address those. First one we'll look at, these are in no particular order, is design. And I talked about earlier how different states, Tort Claims Act may have different viewpoints on design. In some states, design is immune. In other states, it's not. But here's a sight distance issue. This is southern West Virginia. Probably an example of what I talked about at the start. This road was probably never really initially designed. It just evolved over time. And so here we have a crest curve that's very short in length, limited sight distance. And I think you can see what happens just from the tire marks on the road. I call that reading the road. Those are locked wheel tire marks. You can appreciate probably that motorists driving into this image they sort of pop up over that hill, and maybe there's a stopped vehicle on the other side, and so they make a panic brake application. To fix this is probably going to be expensive and time consuming. You probably have to rebuild the road, but maybe we could put up some warning signs or maybe reduce the posted speed limit to be consistent with the sight distance. Or if you have crews that are doing work out here, of course, you want to make sure that the flagger and the advanced warning signs are on this side of that hill crest and not on the far side where drivers may not see the workers or the devices in time to stop. Cross section and slopes can be an issue. Super elevation, the banking of curves can be an issue. Here on the right, on the left, this is another one of the, this is in Pennsylvania, but this is an example of a secondary type road that was never designed. It just evolved over time. And this is an example of what the engineers call adverse or negative super elevation or banking of the curve. Of course, the reason we bank curves like at racetracks is to counteract the lateral forces on the vehicles as they go around the curve. So for a driver coming toward us around this curve, this would be a curve to the left. So the right side of the curve should be higher than the left side to counteract those lateral forces. But notice here, the left side, our left or the driver's right, is lower than the opposite side. And so this is actually going to facilitate a vehicle going off the road. And in this case, again, a tragic situation. It was a fatal crash, but not only did you have the negative super elevation, there were no warning signs or advisory speeds or chevrons around this curve. And so the driver was probably going too fast for conditions, and the truck rolled over and the driver was fatally injured. This is an old photo, but I like it. And I'm not sure if this was design or drainage, but notice the low point of this sag is probably here. And this is where the inlet is. So the inlet is not at the low point, and this area does not drain properly, creates a potential for hydroplaning, or this type of year in Ohio, West Virginia, if you have standing water, that water is going to freeze and become an isolated ice patch, which is also a safety issue. Temporary traffic control, changed conditions. So this is an area that's ripe for tort claims, a variety of different areas. This is a sad one, that signage. This is a stop controlled intersection here. This is what it looks like normally, permanently. But for a few weeks, a few years ago, the road agency had removed a bridge to replace a bridge elsewhere on the system, and this was part of the detour route. And I'm not sure what happened, but the work zone control subcontractor, work zone traffic control subcontractor, placed this detour sign literally within 10 feet of the stop sign. The stop sign is here. It's just behind the that temporary traffic control sign. And I thought I had an image of what happened, but I don't. But there was actually a serious two-vehicle crash by a vehicle from out of state that kind of blew through this intersection because they didn't see the stop sign. So not to get ahead of us, but one of the things I always recommend when it comes to signing like this is somebody should do a drive-through after that temporary signing is up to look for things like this, where the stop sign is obscured. Markings, again, I'm not sure what happened here, but notice there's old markings not removed. There's probably additional markings, in my opinion, that should be added. But to me, the path through this work area is not clear. And imagine on a rainy night trying to find your way through that work area. Devices or lack thereof, at the time of, this is an area, it's hard to tell, but one work zone is ending, the work zone to add another lane here, a third lane in the median, what had been the median. And another work zone is beginning, where out of the image here to the left, we have a bridge that's having some deck issues. So the right lane on the bridge deck is closed. You can see the back of the arrow board here. And that, in my experience, this is those situations where one work zone is ending and another's beginning, and they're kind of overlapping a little bit. That's oftentimes where incidents occur and oftentimes where tort claims occur. On the night in question, and the crash happened at night, these two drums, according to witnesses, were not here. They had been displaced for some time. And a truck driver coming toward us saw the arrow board. He also saw this, which in a few weeks will be a lane of travel. So he moved not only into the left lane here, but moved here. And how little things can make a big difference. Notice this section of temporary traffic barrier here. No one knew how this got here. It wasn't on the plans, but the truck driver said he saw that and thought that that was kind of tapering him to this. This was a pad where the permanent median barrier will be, but at night, it probably looks like a lane of travel to a motorist. So the truck driver got here, and then on the right here, you can see at some point he realized that the roadway ran out, but was not able to stop the truck in time and ended up in the river. Fortunately, he survived, but he filed a lawsuit against the contractor and the road agency, alleging negligent maintenance of devices and also a failure to install type 3 barricades here to indicate that the road ended. And the jury awarded him over $300,000.
Hey, Ron.
Sidewalk work zones, yes.
Question that came in kind of related to that. Someone wanted to know, where is the line between the township and the contractor responsibilities for signage and markings? And townships here in Ohio are our smallest form of government.
I would say it probably should be in the, in the contractor, in the agreement, which shows clearly, or hopefully would be clear on who has responsibility in different situations. Those
Thanks.
written documents are critical. Sidewalk work zones need to be safe. Pedestrians may trip and fall or be injured, but also they need to be accessible and detectable. I mentioned this is not going to be an ADA or a civil rights law class, but to me, this situation that we see here in this scene, and notice there's a lot of traffic control devices, both for motor vehicle operators and for pedestrians. But to me, this is a potential double whammy for a road agency. There could be, if someone's injured, either on the road or on the sidewalk, there could be tort claims, but it appears this sidewalk work zone is also inaccessible, so there could be civil rights, ADA civil right claims associated with this work zone setup. Traffic control devices, signs and markings, another area where claims are not unusual. Could have non-compliant regulatory signs, stop signs. The one on the left would be interesting if there was a lawsuit. The plaintiff's attorney would argue, of course, that a stop sign needs to be red with white with the white lettering showing the word stop, and this doesn't do that. But I think the road agency attorney, if I was playing that role, I would argue, but there's only one 8-sided stop sign, and it clearly means stop. And from this perspective, you can clearly see the shape of this sign. In the middle, that sign is not high enough. It needs to be higher. This on the right is not the correct way to emphasize the stop condition. If you double up stop signs, that means putting another one on the left side of the road, or we could use an oversized stop sign, or we could put a flasher on the stop sign, or we could put LEDs around the perimeter of the stop sign, or we could put a red reflective sleeve on the support. Those are all valid ways to emphasize a sign or enhance the conspicuity of a sign, but this is not. Warning signs, also kind of safety critical. This one is kind of subtle. I'm not sure the motoring public understands, but you can be sure personal injury attorneys understand, and they know the manual. For a 15-mile-per-hour advisory speed, this should not be a curve symbol. This should be the turn symbol like you see in the center photograph. So this does not comply with the MUTCD, nor does this one. The plaque that would be authorized here is an advisory speed plaque, like 10 miles per hour, 15 miles per hour, not the word slow. And similarly here on the right, it looks like they're trying to put 2 warning signs on the same post, which is not allowed by the MUTCD. If you want to warn of driveways, that should be on a separate sign, a diamond-shaped yellow and black sign. The allowable plaques for a stop ahead sign like this, for example, would be the distance, maybe 400 feet to the stop sign. That would be allowable, but not the word driveways. Sign maintenance is obviously important, including the sheeting, also including the sign alignment. Notice this sign, I can tell you it's the same sheeting as the bright signs you see to the right, but notice the sign is bent and twisted, so it's not catching the headlight beam, and therefore it appears as a dead sign. So sign maintenance in all aspects is important. Also pay attention to retroreflectivity for nighttime visibility, and sign supports need to be crash-worthy. This is a steel pipe support that is not a crash-worthy sign support. The roadside. Here's a steep slope. This is a critical slope. Vehicle will overturn on this slope, and notice there's a significant water body at the bottom. So drowning would be a potential if a vehicle enters that waterway. So it seems this would be a good location for guardrail. Someone earlier asked about guardrail. But in some states, as I said, design is immune. The decision to install guardrail or barriers at the top of a slope is a design decision. So that may be immune from suit in some states. But in all states, once we install a device, we need to make sure it's done correctly and it's properly maintained. So notice here, guardrail has been installed, but there's a number of issues with the double railing, maybe with post spacing, certainly with this lack of an end treatment here at the left side of the image. So if someone struck this rail and was injured, I think there would be serious issues in terms of trying to defend that case. Fixed objects along the roadway. The most frequently struck object along roadways in the United States is trees. And you can see here, notice there's kind of a fresh scar here, but notice it looks like at some time in the past, another tree hit occurred at this location, and this would represent notice to the road agency. At least a personal injury attorney would point that out, that, hey, you're aware that a vehicle previously struck this tree. But these can be tough. I appreciate it. Many agencies or many jurisdictions, it's not possible to remove trees. And so I appreciate that that's an issue. What we should try to do in those cases, if we can't remove the tree, is at least maybe install an object marker or put some reflective yellow tape around the tree trunk or something like that. And then don't forget the stumps. I commend this agency for removing the trees, but kind of the key number is 4 inches. Objects shouldn't protrude more than 4 inches above the ground, because this looks like it can strike or catch the undercarriage of a vehicle, snag it, cause the vehicle to stop suddenly or overturn or become airborne. The second most frequently struck fixed object in the United States is utility poles. And you can see here, imagine this roadway at night. There's kind of asphalt. I guess this is a walkway, maybe an asphalt curb here, the asphalt street. It might be very difficult to tell where the edge of this traveled way is. And so it's probably not surprising that some of these poles get hit on a regular basis. Now, at the very least, again, delineate. This, I realize, is a temporary situation, but to me, this is asking for trouble. At night, those poles are not going to be visible, and a driver might turn into that driveway. At least delineate the poles or put some drums here or something, in my opinion, until the poles can be removed.
Hey, Ron.
Yeah.
There was a question that came in, and it's actually about your sidewalk picture from earlier, the work zone area. This individual would like to know, if you tear out sidewalk and replace with aggregate temporarily, because later you plan to completely replace a large section of sidewalk, can that open the public agency to tort claims?
I would say yes, and also potentially to ADA claims, since if it's stone, depending on the type and nature of the stone, it may not meet the firm and stable requirement of PROAG, and so potentially it could, someone could also file a civil rights lawsuit and say, hey, this sidewalk is inaccessible during the few weeks or whatever while construction is taking place. So yeah, surface is important, and I guess maybe what I would recommend is, I'm thinking when it was, maybe it was last week, I did a 3-hour session for Ohio LTAP on ADA and work zones, and actually in that class I talked about surface condition and how to provide accessible surfaces. And I believe, Victoria can correct me, but I believe that's available. It's been recorded and it's available at the Ohio LTAP library. So if you, the person who asked the question, or anyone would like more information on that specific topic, I'd refer you to that particular class, the ADA and work zones class.
Yeah, so we have it available, and I'll send a link out with a link to today's recordings for those as well.
Great, thanks. How about this? I don't know how you'd explain this to a jury, that the pole is in front of a guardrail, which obviously kind of defies logic. And so need to be attentive to these types of things. The tort liability process. What happens in the process from the filing of the lawsuit to, say, the jury verdict? And actually, it all starts with what's called the complaint. This is the legal document where the plaintiff outlines or identifies everything they think is wrong with the roadway. And it can be kind of intimidating to read one of these because, again, they sort of mention everything that could possibly be wrong with the road. And I realize probably most of you would have no reason to see a complaint, but I did want to show a little bit of what's involved with a complaint. And I know this is hard to read maybe, but rather than retype it, I wanted to just cut and paste from an actual complaint. And so we'll look at some of this. I've redacted the names of routes and the defendants and so forth, but this was a fatal crash on a state road involving an isolated icing condition where the vehicle struck ice, slid across the center line, and was T-boned by an oncoming vehicle. So this is the complaint. A couple of things. Notice this is item 37. So there were 36 other items before where they talk about what happened and the driver was paying attention. It was a clear, dry night, but there was an isolated ice patch and so on and so forth. So the actual meat of the thing comes at item 37. And also notice, and I've cut and pasted here, so these aren't consecutive, but these are the specific allegations against the defendants. And I should tell you, this went from A through Z and then started AA, BB, CC, and actually went through TT. So what's that? Roughly maybe 50 individual or separate allegations against the road agency. And of course, we're not going to go over all of those. But notice the first one. It says that the collision and the resulting injuries and death of the decedent occurred as a direct and proximate result. So they're using these terms we talked about before. Direct and proximate result of the negligence and carelessness of the defendant, state DOT, generally and in the following particulars. By failing to properly inspect, maintain, and clean state route, whatever. So that's kind of the overall allegation. In failing to remove debris and sediment from an inlet located on the shoulder of state route, whatever, causing excess water to divert onto the roadway. So the A was kind of general. Now we're getting into the nitty gritty. They're specifically saying that an inlet was clogged and the water diverted over that or around it onto the roadway. In failing to correct defects in the drainage system that are visible to the variety of personnel. That sounds like a little bit of sort of strange wording to me as an engineer, but if you think about it, what they're saying is the DOT failed to correct defects that should have been seen by roadway personnel. So this gets to notice. They're showing that they should have, or constructive notice, I guess we'd say, they should have, roadway personnel should have known about those defects. By failing to conduct a competent roadway inspection. And F, by failing to train maintenance personnel in basic knowledge. And this is something I've noticed in my 40 years or so of doing this. When I first started this 40 years ago, it was rare to see these sorts of allegations. But now this is pretty common. The plaintiff will allege failure to train. And so training is important. You all who are here, I think probably appreciate that, but make sure others in your agency are getting trained in the topics appropriate to their job responsibilities. Because that's one of the first things a plaintiff will ask about is, what was the training? What training did your employees have? What certifications do they have? And those kind of things. So training is critical. And then down here, K, by allowing subsurface water from below the pavement to seep out of cracks and joints and onto the roadway. I mentioned this was really a surface drainage problem, but one thing about a complaint, a plaintiff has to identify all their allegations at the time. It's difficult for them to add something to the complaint. So they kind of have to throw everything out there. And so even though this is a surface drainage problem, notice they're saying, they're talking about subsurface water, just in case subsurface water becomes an issue. And then the last one here, they say, by allowing the defendant property owner to discharge water onto the highway right-of-way in violation of the driveway permit issued by the DOT on such and such a date. So here, they're saying, the plaintiff is saying that the DOT shouldn't have allowed this property owner to discharge water onto the highway. And of course, there's many more. Well, then after the complaint is filed and after the defendants respond, the discovery process begins, and all parties furnish information. That's one of the, I guess, unique things maybe about our legal system, is that all parties in the lawsuit have to furnish relevant information, even if it hurts their particular case. And there's three key elements where road agency personnel may be involved, and maybe three more legal terms here for some of you. One is interrogatories, another is production of documents, and another is depositions. So this is where road agency personnel may be involved in the lawsuit, in the discovery phase. Interrogatories, another legal term. What are interrogatories? They're questions asked in writing by one party and answered in writing under oath by another party. So in the Joe and Sally case, if Sally was suing the city, Sally's attorney might issue an interrogatory to the city asking, when were the headlamps on the city vehicle last aimed? And then the city would respond to that in writing. So it's just a way of gathering information during the discovery process. But a key thing is, notice the questions are answered under oath. So the agency is sworn to tell the truth, that their responses are, truthful. And of course, as I maybe should have mentioned, sometimes the questions that come in, the attorneys are not going to know the answer. They're going to have to go to the field personnel or to the designers to find the answers. And that's where you all may come in. And some of you, I'm sure, have done this already in the past for your agency legal counsel. You've helped them respond to interrogatories by answering some questions. Another thing that happens during discovery is there may be a request for production of documents, which, as the name implies, is seeking documents related to the lawsuit. And these could be plans and drawings, it could be field inspector diaries, could be maintenance records, very likely could be emails, and we'll talk more about emails tomorrow, and probably tomorrow. And so the road agency then needs to gather these documents and provide them to the plaintiff's attorney. And again, the attorneys, road agency attorneys, typically are not going to have access to these sorts of documents or know where they are. So they're going to come to the road agency folks, the maintenance people, the engineers, construction folks, to help them compile this information. And the third area, and some of you have probably given depositions, is depositions. Depositions are questions asked by attorneys orally, meaning verbally, and responded to verbally and under oath. So the person giving the deposition, called the deponent, is sworn to tell the truth. And the other key thing about a deposition is that there is a court reporter in the room, and he or she is recording or transcribing everything that's said in the room once the deposition begins. So it's really a formal proceeding that needs to be taken seriously. And I'd like to talk about some tips for deposition, but since we're just about out of time, Victoria, I think maybe we'll stop here for today and pick up here tomorrow. I want to thank everybody for participating and for your great questions today. Hope this has been helpful, and we'll see you at the same time tomorrow morning. Victoria, I'll turn it back to you for any housekeeping items.
Thanks, Ron. We appreciate all the time that you spent with us this morning, and we're looking forward to the next 2 days. There are a couple questions I'll be sending on to Ron to be addressed hopefully at the beginning of tomorrow's webinar. They came in kind of towards the end, and I didn't want to have those questions stop us from getting to this point. So I'm sure that Ron will be happy to address those for us tomorrow morning when we get started again. So thank you all for your attendance on this webinar, and we look forward to hosting you tomorrow as well. Everyone take care. Stay warm.
Yeah, thanks.